sta facendo entrare tutti, Chiara. Bene, ciao.
Hi.
Hi, Chiara.
Fantastic.
Hi,
You're both
everyone.
here. Great. Hello to everyone. So first of all, welcome. This is a special night. I think we have more Italian participants this evening than we have Japanese participants, but I'm thankful to everyone for joining. And as a reminder, this is being recorded. And so this will be made available to those who could not attend, who are part of our study group. This is, of course, the Japan International Mediation Study Group. I'm James, and we're currently doing a series of interviews with different mediation practitioners around the world to really compare mediation practice domestically and also internationally across jurisdictions. We recently heard from a mediator in the United States. Last time we heard from Aloysius Go about mediation in Singapore. And this evening I have during this session, I have the tremendous benefit of being with two experts on mediation in Italy. So I'd like to begin by introducing them very briefly. Chiara Tondini is one of the directors of the Florence International Mediation Chamber and is really everywhere that one would want to be in the world of mediation in Italy. She has a wide variety of different engagements, including working for the United States government on promoting mediation in Uzbekistan. And Corrado Mora is also with us. Corrado has done more than 1,000 mediations. I think he lives and breathes mediation, between practicing mediation and teaching mediation and doing special mediation projects. Really, we're in great company tonight. We have the two perfect people for talking about mediation in Italy. I think we'll spend something like 50 minutes with our discussion. I'd like to begin by talking about how mediation has developed over time in Italy. Then we'll turn to mediation practice, what makes it distinctive, the practice of mediation in Italy. And then at the end, we'll talk about the administration of mediations and talk specifically about the work of Chiara's Center and about a very exciting new project that they'll be launching soon. Welcome to the two of you. Thank you for joining.
Thank you for the invitation, James.
No. It's absolutely our honor.
It is a privilege to be here in as interviewed capacity.
Yeah, it's really my privilege and our privilege. Thank you so much for joining.
I have to apologize. Sorry for interrupting you.
No, please, Chiara.
Guys, as I see that my account name is Salvini, who is my Secretary General, so I have just obtained a promotion.
Congratulations. I'm happy to share this moment with you.
Sorry, I just now realized it.
Fantastic. Well, as I mentioned, I thought we'd begin talking a little bit about the history of mediation in Italy, because something that's often said about the history of mediation here in Japan is that it's really old. People have turned to mediation as a way of resolving disputes since the 6th century, and it was really built into the first constitution. And I'm wondering, does Italy have a long history of using mediation to resolve disputes?
Who goes?
Chiara, do you want to go first?
Okay. I go first, and please interrupt me if you want to integrate or correct me somehow. Well, mediation in Italy became to be present during the late 80s, early 90s, but exclusively on a voluntary base. And in fact, I remember that when I was a law student during the 90s, in the civil procedure book, mediation was not even mentioned. And just the last 10 pages mentioned arbitration. So the Italian culture, law culture has been always litigation oriented. But during 90s became to be present in the sense the voluntary-based mediation, mostly regarding consumers' disputes. And then in the early first decade of the in 2000, it was enacted the Italian company law reform, which firstly regulated a mediation process in the framework of company disputes involving shareholders and the company itself. But still on a voluntary basis. Of course, a mediation clause was promoted in this framework.
Great. And just Chiara, what was the reason for that? Why was there suddenly this interest in mediation? Where did that come from?
It comes from scholars, and mostly from scholars. And as it was found out that in this framework, interest was involved, but also interest among company shareholders, which as the company landscape in Italy is mostly composed of small and medium enterprises. So companies very often are composed of relatives, families which own companies and so on. So behind the conflict mainly related to business, often there are hidden interests involving family conflicts or inheritance conflicts and so on. Therefore, this mechanism was particularly suited to resolve this kind of disputes. Corrado?
Completely correct. But from a tangible perspective, we came from an age of complete elitarianism in a certain way. Like, it was a very small group of professionals introduced to what mediation is, in fact. Doing mediators or being lawyers suggesting their clients to go through mediation, or having to do, but in just this very narrow range of disputes. And I remember with joy the times when I was meeting colleagues and they were asking about my profession. I was saying I'm a mediator, and they were asking me, oh, so you're a priest? And that was the time. That was the time in the age Chiara was.
Or even more, or even more naively, there's, oh, you are spreading love.
Yeah,
like that.
That was truly. It was not that.
About it. Yeah.
And then things changed a lot mostly with intervention of the European Union and how much it pushed towards mediation. And last but not least, the famous 2008 EU directive that in fact created that huge change in mentality. And it was not just a change as embracing mediation into the legal system as a way for dealing disputes, but also a business. Many people tried to jump on before understanding that in fact, it is not just a matter of doing a business out of mediation, but in fact, it was these two-sided, very extreme situations that were in Italy before and after mediation was made, for example, mandatory, thanks to the European Union intervention.
Okay.
Chiara, did you feel the same?
Completely, yeah. And of course, the big change in the Italian landscape related to mediation has been brought by the implementation of the EU directive in 2010, which has arisen in the current legislation, Italian legislation in the field of mediation. Of course, the two key provisions are mandatory mediation in many commercial and civil matters. Therefore, mediation is a prerequisite to start a court proceeding. The enforceability of settlement agreement.
Right.
And since then many things have changed. Of course, in a litigation-oriented culture, such a such a change have been welcomed by justice actors with skepticalities, sometimes with reluctances, mostly by lawyers. And, but since then, I think that many progresses have come, since also the culture in lawyers have changed. Of course, legal assistants, which are still contrary to such instruments, are still there. The process is not completed, but the common opinion is now convinced that mediation has the legitimacy to compose the range of instruments to resolve disputes, just right litigation, just right arbitration. I think that a very encouraging signal is also coming from law schools, as I see that students are very enthusiastic toward these mechanisms. Corrado, do you think that it is correct?
I'm looking at the list of students who are attending, so I think this bears out exactly what you're saying.
And they can confirm when we organize events or initiatives which involve students or students simply attending our conference or seminars, they still ask me how we can undertake a career in the field of mediation or in amicable dispute resolution mechanisms. And 20 years ago, this was even not foreseeable. So I think if we look behind us, we see that many developments has undergone. Still, I think that we can think a lot about whether it is good to foresee mandatory mediation, as mediation a per se voluntary process.
Right. I'd like to talk about that. I'd like to talk specifically about, first, I'd like to try and understand the process itself. When you say mandatory mediation, does that just mean that the parties and mediator have to meet, or does there actually have to be something beyond that?
Also, this aspect of the process has changed throughout these 10 years of enactment of the Italian mediation law. Mediation. Initially, it was required that the parties meet and started to mediate. Of course, it was not required that they settled, but parties were forced to meet and to start mediating, and consequently to afford the mediation expenses.
Okay. And was that a court-sponsored process? When they were mediating, were they using private mediators or were they using court agents?
Okay, these aspects are all specifically regulated by the Italian Mediation Act. Mediation was managed out of court, not in court, by authorized mediation institutions, which can be both private and public. And the public mediation institutions in Italy are by the Chamber of Commerce. Corrado is correct. There are no others. Public institutions, private institutions, private mediation institutions are mostly held by local bar associations.
Okay.
And alongside, there are also completely private institutions held by private companies. All of them must be listed in a specific chart held by the Italian Ministry of Justice and must respond to specific requirements, which are mostly accountability requirements and reliability requirements. Along this list, there is a list including authorized and accredited mediators, which must comply with specific requirements. The mediation institutions must operate exclusively through these authorized and accredited mediators. The role of the court is different. I mean, the court may encourage mediation through court-ordered mediation, but the mediation ordered by the court is always managed by the mediation institution, which means outside the court. And parties are free to appoint the mediation institution which they consider most suitable for their exigencies.
Great, great. Now, going back a little bit, you started to explain that originally mandatory mediation meant that the parties go through the mediation process. And then I think you were about to explain a change.
This was badly perceived, of course, in front of a general reluctancy to the instruments. This was took as a basis for challenging the law for the Italian Constitutional Court, alleging that it infringed Article 24 of the Italian Constitution regarding access to justice. I mean, it was alleged that since mediation was not out of charge, but on the other hand, it was mandatory, it was an obstacle to access to justice. That is why this challenge was supported by the lawyers community, Italian lawyers community. Right. And the constitutional courts ruled in favor of them. That is why this provision of the Italian law, Italian Mediation Act, was not in force anymore. So for about 1.5 years, Corrado, correct, mediation was not mandatory anymore. And the provision was reintroduced in the law, setting forth that in order to, there is a lot to speak about on this aspect. I try to synthesize as was reintroduced, setting forth that the requirements of in order to be allowed to go to court was satisfied by simply taking part to a first mediation meeting in which the mediator had to explain party the function of the process and asking them if they really want to start the process. If at the end of this first meeting, parties decided to not proceed in the mediation process, the requirement was anyway satisfied and they were allowed to start the court proceeding.
All right.
Important, this first mediation meeting is mostly out of charge. There is just a symbolic administrative fee of less than 50 euros to be paid. Of course, consider that in a litigation-oriented culture and when lawyers attend the mediation meeting and the provision included in the reform of the Mediation Act set forth that the lawyer's presence is mandatory. So this kind of mediation can be exclusively conducted with lawyers' assistance. Of course, lawyers are encouraged to use this provision to not start the mediation meeting if lawyers are reluctant to the process. I think it is a weapon not charged, something like that.
It is. We are famous for a way of saying that is when you tailor a rule, you already found a way for moving away from it.
Right.
So in fact, that was a destroying package that was created at the very beginning.
I think that it is important to mention that in the Florentine court was a pioneer in trying to put a remedy to this weakness of the process. And it was issued an order by a judge in Florentine court, who is very committed in encouraging and promoting mediation, which in substance set forth that the requirement of trying mediation is not satisfied by a simple explanation by the mediator of the process, as lawyers have primarily and before the mediation the duty to prepare parties to mediation. So it is the first mediation meeting must include also a first attempt to mediate.
Okay, and that's the current situation, is that right?
Yes, that's the current situation, and this order has been borrowed and adopted since then, also by many other courts in Italy.
So what does that mean in substance? Maybe I'll share your burden with Corrado for a second. What does it mean in substance? Do the parties actually have to provide written explanations of their positions before the meeting, and do they have to actually engage on the facts?
No, it is in fact that the very beginning of the application of this rule was, as Chiara pointed out, just lawyers coming to waste their times and your time as a mediator, like coming in the room saying, I understand we don't want to go ahead. You can close the mediation down here with no payments, no mediation in fact, and that is perfectly fine with law. What happened after the revision of the Florentine jurisprudence, which now became somehow national-wide, is that they crafted an ordinance in such a way that the parties are in fact mandatorily prescribed to go through the mediation after this very first pre-mediation meeting. And in case they would not go ahead, the judge will in fact take note of that and of course deal with the fact that the parties, despite his order, they didn't go through mediation, and sometimes they are forbidden to go through the court again. So you have this kind of two-sided approach. What I perceive mostly in the places where mediation is somehow more advanced here in Italy, I'm talking about Florence, Milan, for example, is that you don't have to, well, you have parties and lawyers in the room which are walking a kind of an in-between line between not going through mediation or having to go through mediation because of the judge ordered, which is, I now understand what mediation is. I had the chance to understand that mediation is not just a one-sided event made in the very same way, but all mediators and all mediation providers, now they are becoming more and more sensitive about how mediation can be differently performed and how it can be differently successful. And so they are choosing with more knowledge and understanding which mediation provider and which mediator to choose to have their dispute somehow managed and piloted through the mediation process. So this is a third way, which is little by little growing, but it is visibly growing, which is something that of course makes me completely glad, because it is what it should be. And in this perspective, a pre-mediation meeting in the sense of the law would be effective. Like you meet with the parties and the lawyers, explain what mediation is and your kind of mediation is. And in this way, you have them informed to be able to decide whether to go through this, well, heavy, difficult conversation, which mediation is or not.
Great. So I imagine this must have been quite a challenge to find qualified mediators, because if I've understood, when the first law came into effect that made mediation mandatory, parties had to go through the process, and yet there wasn't a culture of mediation. So where did the mediators come from, and how were they trained?
Well, of course, there was in 2010, when the Mediation Act came into force, there was already a first community of mediators which operates since at least a decade in the field of voluntary mediation. Corrado was one of them.
It was the group of the priests.
Yeah. Definitely. And they, of course, started to operate more massively rather than before, but they were already prepared to face the process, as, of course, voluntary mediation was quite challenging at the beginning. Then the Mediation Act set forth that graduates which wanted to undertake the career of mediator must attend a course composed of 50 hours training with a final assessment in order to be included in the Ministry of Justice list of accredited mediators. Well, you can imagine that 50 hours of training are not sufficient to effectively mediate. Therefore, we had the first community of mediators which were skilled and prepared. A first portion of mediators which had simply attended the 50 hours course, but believed in the instruments, so they were very engaged in learning and improving their skills and so on. Another part of professionals which were attracted to try this career by the expectation of huge number of mediation, considered that the process was mandatory, but first discovered that it was not rewarding, as mediation fees for mandatory mediation are very, very low.
You really were priests. You really are a priest, aren't you?
Yeah.
You're not concerned about the money.
We work for being saints, of course.
In the last time, sensitiveness toward this aspect is changed. I mean, it is arising an awareness that if you want quality and skilled and prepared mediator, you have to encourage them to invest in their professionalities and so on. So things are changed, but the situation has been this one for many years. So during the years, the mediators communities has raised their preparation level, and now I think that we have skilled professionals which are capable to understand parties' exigencies and to adapt the process according to parties' needs and according to the case-by-case situation. So I think that today we have good quality of mediators.
Yeah, which is in fact a kind of process that would have been better to be somehow upside down. So now you are, and it was happening like 8 years after the rule, the mandatory mediation rule came into act, that in fact you had a community of such and many mediators to be able to handle the mass of mandatory mediations. At the very beginning, it was like gifting an 18 years old guy just fresh of the driving license with the most powerful Ferrari around.
Yeah.
So just go and crush yourself on the wall. Because you had this mass of mandatory mediations, and in fact, a very narrow and unexperienced, mostly, community of mediators. Of course, both the ignorance and climate change for the lawyers to have to deal with mediation, something completely new, and the inexperience of both mediators and mediation providers created the crash. And it was very foreseeable by all means, and it would have been better to put the process somehow upside down, having, first of all, a community of mediators structured and prepared and trained and continuously trained, and then little by little to start enlarging the mass of mandatory mediation cases.
Right.
That would have created less friction, probably.
Yeah, yeah. I imagine that would pose. Sorry, go ahead, Chiara.
I would like to add a consideration that in addition to the difficulties that Corrado have just described, in 2013, when mediation came again mandatory after the reform due to the Constitutional Court judgment, a provision was included foreseeing that lawyers admitted to the Italian bar were automatically mediators. Therefore, they didn't need to undertake the 50-hour training course.
Oh.
This made the situation even worse, as of course you can imagine that you can be an excellent lawyer, a brilliant lawyer, but it doesn't mean that you are a brilliant mediator. Or often the two things are difficult to combine. You see, are completely different perspective. And of course, this was crucial, the approach adopted by mediation institutions. I mean, many mediation institutions decided to undertake an additional assessment before admitting mediators to mediate for their cases. It was not sufficient that they were included in the Ministry of Justice mediation list, and the Florence Chamber of Commerce adopted this decision. It was not good perceived, but I think that it was necessary to protect parties' interests. Now I confirm that the situation has changed, as Corrado was considering earlier.
Great, good. I was curious about the process of mediation. So when a mediation does go forward, I was wondering if there's a particular style of mediation that's predominant in Italy. And I was wondering about things like joint sessions versus private sessions, and whether you meet together in the mediation and you go for many hours, or whether they're spread out. What's the process generally like?
Well, I think that the general process, which is somehow coming since the very beginning of times here, is the facilitative process. So the usual third party neutral who meets with the party, helping them, facilitating their communication and negotiation, but without intervention in terms of the substance of the dispute, and mostly how the parties wish to handle the possible solutions. Then within this spectrum, I think that we also, Chiara, correct me if I'm mistaken, whatever kind of possible differences. So you have the pure facilitatives, and then you have very advanced professionals, mediation professionals, who in fact apply some even narrower, more peculiar models, like being transformative, for example, mediators. Then you have some mediators which manage to obtain less experience or a different training, who are in fact calling themselves facilitative, but they are everything but facilitative, under the spectrum of facilitative. So you can have whatever inside this being facilitative, even if facilitative is the main model.
And what about joint sessions and private sessions, and how long the mediation tends to last?
The traditional courses were in fact structured with the standard idea, I would say the international standard idea of having joint sessions and private meetings, or at least they provided the mediators with these tools of having different sessions for performing different activities and creating different comforts for the parties and operative zones for them to walk in. Then, of course, there are some professionals, the transformative ones, for example, who even if they explain the rationale of a private meeting, they somehow nudge the mediators to go through the whole mediation in a joint session for the purpose of a transformative mediation. But I would say that, in fact, what I see is mostly the application of the standard process with an opening joint session and then through caucuses and for reaching again joint session, more or less shuttling, more or less coaching the parties for joining again. Then it came the online mediation. Then that changed a little bit, as in the entire world. It happens in Italy as well, that we had the complete paralysis of the justice system in March when the first lockdown came into force. So all the justice went completely locked down, but mediation, which immediately started to perform online, of course, very effectively, and it received a push by the common practice enterprises and government somehow for continuing to perform. And then, in fact, online mediation changed, as it is, of course, foreseeable, the process itself and the modality of intervention. And so also the rationales of having joint and private meetings, it fractured it a little bit. Chiara, do you agree with that?
Completely. Yeah, completely. And in any case, I think that you can confirm it, Corrado, that the Italian parties, as per I see, feel mostly comfortable with the facilitative approach. I have assisted to mediation conducted according to the transformative approach, but I have observed that it is quite consuming for parties. I have seen parties asking to the mediator to have private caucuses, private meeting, just to share with the mediator concerns or information that they wanted to share directly in front of the other party. And the mediator very kindly, with much empathy, explained that the process didn't include this aspect, didn't include this phase, but I think it is difficult, and I wonder if it is appropriate to deny to one party who asks and which share with the mediator the exigence to share some information in private, to deny this opportunity and this possibility. I mean, it is good to prefer an approach rather than another, but I think that the mediator must be ready to follow the flow of the process and to be extremely careful to parties' requests.
Yes, indeed. Great. I don't mean to put you on the spot, but I was wondering if you have any sense for how often the initial meeting leads to mediation and how many mediations are actually successful. Do you have any sense for the numbers?
Yeah. In fact, when parties go start the mediation meeting and then decide to go ahead further to the first meeting, according to the Florence Chamber of Commerce data, they settle in 53% cases. And the data is higher when, of course, we have court-ordered mediation, considering the contents of the ordinances of judges, which we explained earlier. Parties decide to go ahead after the first meeting in 50% cases, according to the Chamber of Commerce data. In any case, the numbers have increased during the years. So it confirms Corrado's considerations about the increased awareness and appreciation by legal community toward the instrument. And if I have a little time, just 1 minute, I think it is worthwhile to mention an initiative undertaken by the Florentine community, which has arisen in a pilot program, which has been also adopted by other Italian courts, which consists in a synergy among all the mediation actors, among local court, local bar association, in our case, the Chamber of Commerce as a mediation institution, and the local university school of law, in order to encourage and increase sensitiveness of parties toward mediation. And in a nutshell, it consists in the fact that the University School of Law make available postgraduate scholars in supporting the judge to examine the lawsuit files in order to evaluate which cases are most suitable to be settled through mediation. Then the postgraduates submit the cases to the judge, which of course made their own evaluation, and if this is the case, issue a mediation court-ordered mediation.
And would that be during the ongoing litigation? So there would be an analysis during the litigation of the case, and then does that mean the mediator would tell the parties that she thought they should mediate, or would the mediator direct the parties to mediation? Would it be mandatory?
The judge direct the parties.
Yes, exactly, the judge.
Yeah. And the postgraduates which undertake an intern by the local court support the judge in examining the cases. And I have just one data on 3,500 cases submitted to the judge. They decided to direct to mediation 1,100 cases.
Wow.
And 70% of them have been settled. Of course, the earlier the judge orders mediation, the more probabilities are there that the case be settled. In any case, I think that has been a good example of synergy and how we can join forces to make parties appreciate the advantage of the instrument and make parties benefit of the advantage of the instrument.
That's
I completely agree. Just if I can add on something about that, is that one data that is really fascinating me is that through the years, after having had this mandatory mediation system and this rising judiciary mediation, like the ordinance from the judge, what you can see is an increase year by year of the number of the voluntary mediations, which is in fact meaning just one thing, that the parties didn't know what mediation was before, they had to go through mediation because of the law or because of the judge, they liked the product and they came back, even in a case where it was not the law or the judge pretending them to go through mediation. So choosing it voluntary, which is data which is fascinating me. It comes back to the real nature of mediation process, and it makes you to understand how sometimes for getting knowledge about the process, you have to be forced to use it. You have to be forced sometimes to go out of your comfort zone as a lawyer or as a client, entering into such a difficult, new, innovative, and unknown process before, but embracing it after as something very effective and useful.
That's really interesting. And that's actually a good segue. So now we've talked about the development of mediation in Italy, and we've seen this particular development of mandatory mediation. And now I'd like to talk a little bit about international mediation. So it seems that Italian companies have become sensitized to mediation generally. Has that carried over into mediations in contracts with parties from other states? Is there a growth in international mediation in Italy?
Not yet. I mean, in Italy, the use of international mediation, I think that reflects the general feeling toward international mediation, which we have globally. International mediation is still much less used than international arbitration. Of course, this considered that internationally we cannot yet benefit from the enforceability of mediation agreements, and on a domestic level we can benefit of enforceability of mediation agreement. There are encouraging signals mostly from companies which are revealing interest in this instrument. But I think that yet we don't have substantial results in this framework. Corrado?
There is still a big difference between city and city, I would say. There are cities like Florence or Milan where the activities of FIMC, the Florence International Mediation Center or Chamber of Arbitration of Milan, are deeply involved with this kind of international environment, having big companies, structured law studies and law firms that are breathing mediation as a tool for solving disputes internationally. And in fact, numbers are much larger than other centers where, in fact, even if they could have this kind of an international environment because of connections, still mediation is something completely connected with domestic disputes, so not very used in international affairs. So I have feelings which are in fact biased by being very active on the field of in the environments of Milan and Florence. So I can say that I see many international mediations, but I perfectly understand how it is just a small drops in an ocean, which could in fact enlarge and increase thanks to the nature of international mediation.
Great. Well, then could I maybe turn back to Chiara? Could you say a little bit about the Florence International Mediation Chamber, the kind of work that you do, and how that's evolving?
Yeah. Well, the Florence International the idea of establishing an international mediation service in Florence was suggested to the Chamber by in-house councils of branches of multinational corporations seated in Florence. As of course, they had the perspective of the global framework at that time. They are users of these instruments. That is why they represented to the Chamber the exigence to have an international mediation service in Italy and specifically in Florence. The Chamber decided to capitalize the experience gained in the domestic framework, and then to enlarge the landscape to international proceedings.
Mm-hmm.
But of course, the first concern that we faced was about quality of the mediators involved. I mean, today, international mediation is indeed a hot topic. We all talk about international mediation, both in commercial and investor state fields or interstate fields. And I am convinced that it is the instrument that is going to have the most growth in the near future. But 6 years ago, it was not the case. That is why we decided to adopt standards for mediators in order to guarantee the quality of professionals involved to parties. And I go back. We immediately realized that we couldn't manage the service according to Italian Mediation Act. So they manage the service in order to meet all parties' exigencies and all possible legal framework involved must be managed out of the scope of Italian Mediation Act. And then the problem of assessing requirements of mediators arose. That is why we decided to include in the mediators list only mediators which was certified according to the International Mediation Institute standards.
Right.
And this allowed us to enroll in the list mediators from all over the world with every cultural background, with every mediation styles and so on, but going beyond the application of the Italian Mediation Act. And what is the situation after 6 years? I think that many developments have occurred. In particular, we have liaised with the leading international ADR institutions, international mediation institution. And of course, I want to quickly mention the project we have just carried out with the Tashkent International Arbitration Center.
Yes.
I had a personal note to again thank you, the two of you, for having cooperated with us, and your contribution has been fundamental to achieve the result.
You're too kind.
And
thank you.
Going to the merit of the process, the country of Uzbekistan have just enacted, or better, in 2019 has enacted their first mediation act, and therefore decided to ask the Chamber of Commerce of Uzbekistan, which manages the Tashkent International Arbitration Center, was in charge by the country of Uzbekistan to establish their first international mediation institution, and asked the FMC to support the establishment of the institution, considering that operating in Italy, the FMC have already an experience with a legal framework of the process. This is one kind of cooperation that we have. On the other side, we cooperate with the Permanent Court of Arbitration in The Hague in order to promote the use mediation in the investor state disputes, and in general, more generally, in disputes involving public parties. In a nutshell, a particular matter in which we found out that there is a need to resolve dispute through a flexible mechanism is art dispute and cultural property dispute.
Right.
We found out that there is a huge amount of dispute in this sector, of course, arising from the aspect that during the years, ownership of artworks has changed, and there is a stratification of different legal framework and conflict of laws, conflict of jurisdictions, and also party interest have substantially changed in the course of the year. That is why flexible mechanisms are the most suitable instrument to resolve this kind of dispute. And often these disputes involve public parties such as states or state-owned museums, state-owned auction houses, and so on. So this is the path undertaken by the FMC during the years. We have actively supported during the working group session the achievement to approve the Singapore Convention and the amendment of the law or the model law. And we don't know how, I don't think that our contribution was, of course, determinant and key and fundamental to achieve the result. It was not, but we convincingly support the enactment and of this instrument by the United States.
Wonderful. Good. I know we're approaching an hour's time. If I could trouble you though, just for a couple more minutes, I was hoping you might say a word about the new academy. I don't know how much you can talk about it at this point, but it seems like a really, really interesting project. So I thought that you might just introduce the idea.
Yeah,
I just mind me for 1 second. I have to disappear 1 second. Troubles of home working. I will come back in a second.
Okay. Yes, there is a brand new project of the FMC, which has arisen by the synergy with the Chamber of Commerce Internationalization Department. I mean, the colleagues involved in this department found out that in supporting companies in entering in the global market, there is a lack of knowledge and awareness of companies in how handling international commercial relationship. Also, or mostly in the perspective of preventing disputes and managing disputes in an effective way, effectively addressing their interests. That is why we have decided to establish an academy which has the mission to raise awareness in parties, in all commercial parties, from small and medium enterprise to global corporations, to manage as actors, not as attendees, the prevention and resolution of their potential disputes. So the trainings will address topics such as negotiation of international contracts, assignment of international contracts, how to negotiate the dispute resolution clause, and how to choose the international mediation institution, how to choose the international arbitration institution, how to appoint professionals, and so on. There will be 2 levels of trainings, one basic skill training and one advanced training, just in order to try to cover all exigencies of parties' exigencies. So this is just in a nutshell.
Fantastic.
And the service will be launched the next 20th November with through an online event.
Fantastic.
In the meanwhile, I'm sorry. I hope you can hear me. I don't see myself. Probably there's a kind of a crash because parties of a mediation that is going to begin now are ringing at the bell somehow.
James, I don't want to add anything.
I'm so sorry.
I think that's a really good note to end on. This is blending this meeting with actual practice. Thanks so much to both of you. Thank you to all who attended right to the end. We're really grateful for your time. And we look forward to continuing the conversation on another occasion. Thanks, everyone.
Thank you. Thank you, James.